Plus, on behalf of Mehta and Mehta to welcome you to the weekly knowledge sharing webinar conducted by Mehta and Mehta. And as you are aware that we have been conducting the series of masterclass webinars on the Companies Act, and we are revisiting the Companies Act. Last week, we actually discussed about the appointment of the directors. And in continuation with that, today we will be talking about disqualification of the director, rights of director, duties of the director, removal of the director. All those related topics we'll be discussing it today. And for today's webinar, we have Mr. Shanmugha Sundaram, who is actually known to us. He was there earlier also in our webinar. We all heard from him. He has got a very expert knowledge over more than 2.5 decades of the experience in his field. He is also our own colleague, company secretary. Can you change the slide, please? As you are aware, he has been actually involved in multiple areas like compliance, legal, governance, and secretarial things. And he is also a qualified law graduate, and he has also done his post-graduations in finance and also insolvency and bankruptcy professional. And then he is well-versed in his own field, and he is a well-known speaker across the country in many forums. I don't think I need to elaborate more than that because we also heard him earlier. Many of you would be definitely remembering his great contribution he made in the past as well as today. We are definitely looking forward to hear from him his personal experiences and the typical problem associated with this matter. In fact, he is also one of the research scholar. He has actually brought out various research material on the related field, and he has got the many recognition for that. And today, due to some preoccupation, Dipti is not going to be joining us. We will be missing her. Sudhakar also has some sort of a preoccupation, but he indicated if possible he might join. I'm not very sure about that. So I think without wasting much of the time, I would request Mr. Shanmugam to share his thoughts on this particular topic, and then we move forward. Over to Shanmugam, please.
Yeah, good morning to all. I thank you, Mr. Bala, Disha, and Mehta, and Deepthi for giving me this opportunity. And this is not the first time I'm being part of these webinars organized by Mehta. It has been a great privilege and learning for me as well in terms of the very important topics which Mehta chooses and supports the professional fraternity in updating their knowledge as such. And the topic we have today is one of the important topics in terms of the directors' disqualification powers, then their removal and all that duties and liabilities. So from the corporate standpoint, this is one of the important area where every professional needs to be aware of the nuances, because some of these provisions, which could directly impact the director's position in a company as such. It could be a vacation or it could be disqualification, which applies at the time of appointment. Vacation applies after he is appointed, when he is a director in a company. Disclosure of interest, such as under 184, is also an important provision, because a non-compliance of that would also lead to vacation of office of director. And Isha has prepared a wonderful presentation in terms of the content. I'm sure all of us will have a great learning today for the next 2 to 3 hours. I look forward to an engaging conversation with all of you.
Over to Disha, you can start your presentation.
Yeah.
Okay, sir. So my screen is visible? Hello? Hello?
Yes, Disha. For me, it's visible.
Okay. So very good morning to all of you. So today we are going to have a webinar on Masterclass on Companies Act 2013. This is the 22nd webinar. So the topic is insight into the duties, powers, disqualification and removal of directors. The concept which I am going to cover is Section 164, disqualification for the appointments of directors, Section 166, duties of directors, Section 167, vacations of office of director, Section 168, resignation of directors, Section 169, removal of directors, Section 179, powers of board, 180, restriction on the power of board, and 184, disclosure of interest by the directors. So very first, we will take a disqualification for an appointment of directors. So the person who has declared of unsound mind by a court is ineligible to become a director. The person who is undischarged, insolvent, or has applied for insolvency and the application is pending is disqualified to be a director. If a person is convicted of any offense and sentenced to imprisonment for not less than 6 months and a period of 5 years and has not elapsed from the date of expiry, if a person has been convicted of any offenses and sentenced in respect thereof, imprisonment for a period of 7 years or more, he shall not be eligible to be appointed as a director in any company. So the order of court or a tribunal, then person is eligible while the order is in force. If any person who has not paid a call on shares held of 6 months after the due date, then he is disqualified to be a director. Then a person is convicted of offense related to related party transaction under Section 188 at any time during the last preceding 5 years, then also he is disqualified to be a director. Then non-compliance, if the person is non-compliance with Section 152(3) and Section 165(1), that is, he has not obtained the DIN and he is having a directorships in exceeding 20 companies, then also the person cannot be eligible to be a director of that company. So Section 164(2) mentioned that no person who is or has been a director of company which has not filed the financial statement or annual return for the period of 3 years. If a person has also failed to repay the deposit accepted by it or pay the interest thereon, to redeem any debentures on the due date or pay interest due thereon or pay any dividend declared, and such failure to pay or redeem continues for 1 year or more, shall be eligible to be reappointed as a director of that company or appointed in another company for a period of 5 years from the date on which the said company fails to do so. Section 164(3) mentioned that a private company may include additional disqualification in its articles. The disqualification related to convention, court orders, or related party transaction continue to apply even if an appeal or petition is filed against the order of conviction or disqualification.
One thing is very clear, which is coming out. Without having a DIN number, no director can be appointed as a director. If company is actually thinking, subject to obtaining the DIN, etc., the appointment which will take place after appointment of the date of the getting the DIN and all, that is all not going to hold good. Because now the regulator has actually modified while applying for the DIN application, he has to also attach the letter in the company in which he is intended to be appointed as a director. Mr. Shanmugam, you can add something.
Yeah, earlier what companies used to do is that, they used to appoint him and as well as, parallelly obtain the DIN number. But that cannot be done anymore. First, the person has to apply for the DIN, get the DIN, then only the board of a company can even consider the appointment, actually. DIN has become a prerequisite, actually. You're right.
And it is also a customary, while writing the appointment in the resolution, we have to write along with his name, the DIN number as well.
Yeah. Correct.
Yes, go ahead, Disha.
Yes. So Rule 14, disqualification of director, subsection 2 of Section 164 is every director shall inform the company of any disqualification under Section 164 and 1 and 164(2), if any in Form DIR8, before he is appointed or reappointed. When company received this Form DIR8, then company within 30 days of that such receipt has to file DIR9 with the registrar. So in Tier 9, you have to also have to attach the court orders mentioning if any disqualification has been received. A company fails to file financial statement and annual returns, repayment deposits, interest, dividend, or redeemed debentures. It must immediately file DIR 9 with the registrar, furnishing the name and addresses of all director during the relevant financial years.
There is one question has actually come. I have one doubt if there is one director who is also a designated as a partner in LLP, but that LLP has not filed the Form 8 and Form 11 annual return for the last 3 financial year, then whether that person who is actually designated partner who also happened to be a director in several other companies become disqualified under Section 164 of the Companies Act. Whether the provision of the Section 164(2) are applicable for LLP annual filing, also kindly advise.
I think in February 2022, MCA issued a notification in this regard, applying certain provisions of the Companies Act for the LLP as well. My understanding is that this 164 applies to LLP filing also.
You are absolutely right. I also agree with you what you say, because LLP will be treated now in par with the Companies Act. So whatever the non-compliances will definitely attract. That is right, absolutely. There's another question has been actually put up. In case of the private limited company, 3 directors are there. All are shareholders also. Director A holds 96%, is managing the affairs of the company. Other directors, B is the wife 2%, and C is 2%, brother of the majority shareholders, director. Due to certain differences of Director A called the EGM and removed Director C without giving any opportunity for any lapse on his part. If this removal would be as per law, kindly advise. I think she is going to discuss the removal later. I think that time we will take up this question. And another thing is there, sir, while filing the DR12, it is seen that the appointment date can precede the DIN date. Does this mean the date of the appointment is irrespective of the date of generation of the DIN?
Maybe a provision in the form, but as per the provisions of law, it will be wrong. It will be a non-compliance actually to appoint somebody without a DIN.
Correct. You cannot appoint at all. Because DIN number is a must while appointing it, and that also has to be mentioned.
The form has not built up that restriction.
Yeah. Yes, Disha, go ahead.
So if company fails to file Form DIR 9 within 30 days of a failure, that would attract the disqualification penalty on the officers who is in default as per Section 260. So officers in default are the KMPs of the company, directors, managing directors, company secretaries, and everyone. So after receiving Form DIR 9, the registrar must immediately register the document and make it available for the public inspection. And any application for removal of disqualification of director shall be filed in Form DIR 10 before the regional directors.
When you say actually officers in default, I think law makes it very, very clear that managing director, if the company has actually designated a person as a managing director or any particular person as a CEO who is responsible for running the cameras, he will be an officer in default. In the absence of any such, designated person, all the directors would be actually coming under default of the entire board will come. Yeah.
See, one point I would like to add here is 164 applies at the time of appointment. Okay. Yeah. Go ahead.
So Section 166, duties of directors. So first duty of the director is to comply with the company's article of association. Second is to must have a good faith to promote the company's object for the benefit of his members, employees, shareholder, community, and the environment. He has to exercise his duty with the due care, skill, diligence, and independent judgment. He has to avoid the conflict of interest, which has direct or indirect interest, or possibly may conflict with the interest of the company. He has to prohibit any undue gain which is achieve or attempt to achieve either to himself or his relative partner or associates. And if such director is found guilty of making any undue gain, he shall be liable to pay an amount equal to that gain to the company. Then director shall not assign his office or any assignment so made shall be void. Then the penalties, if any of the provision is contravenes, then he shall be punishable with a fine which shall not be less than 1 lakh rupees, but which may extend to 5 lakh rupees. From apart from the duties which are mentioned in Companies Act, there are the other responsibilities of the board of directors and the functions which are mentioned in SEBI LODR Regulation 4F. For the listed companies, they have to follow that also, the responsibilities and the functions.
Yeah, you are actually right. In case of the listed companies, all the listed companies are actually bound by the LODR regulations. Since it is the Companies Act provision we are discussing it, we are not going in detail on the LODR regulation as such. But however, the listed companies are required to adhere whatever the requirement is coming in the LODR regulations. Yeah.
Nisha, can you go to the previous slide? Just a couple of
Yes.
points I just wanted to emphasize or highlight.
Yeah. Nisha?
Yes,
That is
sir.
relating to the directors acting in good faith. One of the salient, important aspect is, something relating what they have mentioned to the benefit of the environment. So companies which are into the business by very nature, which can impact the environment, they need to be careful of this provision where it has been mentioned as one of the duty to work for the, benefit of the environment. Anything which the company's business impacts the environment, those directors have to exercise a lot of diligence or necessary, precautionary measures. That is one. The other one is the next point. They are expected to exercise independent judgment. So no director can act in association or in alignment with other directors and any of the businesses unless and until it is a bona fide or it's a genuine, proposal. So irrespective of whether the person is an independent director or not, this particular provision which emphasizes the need for independent judgment for all the directors. This thought I would emphasize these points.
One more question has actually come. If after obtaining the DIN, the respective company did not appoint the individual as a director of that company, what action is required to be taken by the company and the appointee director?
Oh, that you cannot do. No, if the company doesn't choose to appoint him for some reason.
Yeah, you're right. You're right. Actually, in this particular case, the company's intention was to appoint him. There was a prerequisite to get the TIN number. He got the TIN number. Now the company has actually changed its mind. Either there is no compliance coming or nothing. Because the company has changed their mind, they're not to appoint him. I don't think there is any action can be taken either by the director or anybody else on this matter. But however, the DIN will continue to be valid because whenever you appoint any other company, the same DIN will be used for the other companies as well.
I think there is also provision for surrender of DIN in case the company.
Yeah, in case he is, in case he is not going to become a director, he can surrender the DIN. That is there. Yeah. Yes, go ahead, Disha.
So section 167 is the vacation of office of director. So first is disqualification. If a director incurs any of the disqualifications specified as per section 164, their office become vacant. And for disqualification under sections 164(2), director must vacate office in all the company except the one in which the default occurs. So if he is not attending the meetings of the board over a period of 12 months with or without seeking a leave of absence, then also the vacation of the office of directors are. If the director is
12 months, this 12 months, there are multiple interpretations that you will have to take the calendar months or from day to day, the month has to be calculated. There are multiple interpretations there. Do you have any views, Mr. Bala, on that?
No, somewhere law talks about the financial year, somewhere law talks about the calendar year. But I think when you are talking about here 12 months period, 1 year period, I think the last meeting when he has obtained, when he has attended the meeting, from there onwards you have to calculate 12 months, I think.
Yeah, that seems to be the interpretation of majority of the professionals.
Yeah, because if he has attended the board meeting in the month of April, From that time onwards, the next 12 months has to be
12
calculated,
months.
irrespective of either financial or calendar year. That is what I would definitely think. That's what the law also look forward. That is the spirit of the law, I think.
Yeah, I agree with your views.
So if the director contravenes to section 184, that is disclosure of interest by the board relating to contract or arrangement in which he is or indirectly interested, and if his failure to disclose his interest in any such contract or arrangement in which he is directly or indirectly interested, then also he has to vacate his office as a director.
And one more thing is there, here it is stating very clearly the director must vacate the office. That means the vacation of the vacation happens instantly and immediately. There
It's
is no
automatic vacation.
Yeah,
Correct.
automatically the post stand vacated actually. There is no question of submitting resignation, that etc. No procedure and nothing. The post stand vacated immediately under the default conditions. Yeah.
Yeah, here the 184 non-compliance is the most significant one, because that could even happen inadvertently, where a director may become a director in any other company, and if he somehow misses to give the disclosure, and there is a transaction with that company by the other company, and he fails to disclose, then it's a vacation. It's a very significant provision actually,
In
which
fact,
could be inadvertently non-compliant.
In fact, she's going to discuss the disclosure also. In fact, when you come to the disclosure, there are two parts of the one. One is the disclosure which are required to be made by the director himself. That is one. If he is not making the disclosure, then that will come under the non-compliant. Second thing, even after making his disclosure, if the company has actually not taken it on record, then it is on the part of the company. That also become a non-compliance, because with the reference to the disclosure only, all the things are all coming out of it. When you talk about the related party transaction, when you talk about the number of directors, etc., other thing and all. Anyway, that we are going to discuss. Yeah.
So if there is any order which has been passed by the court or tribunal on the director, then also it disqualifies the director and he has to vacate the office as a director. If any conviction or imprisonment, then convicted by a court of any offence, whether involving moral or otherwise, and sentenced in respect thereof to imprisonment for not less than 6 months, provided that for 30 days from the date of conviction or order of disqualification, where an appeal or petition is preferred within 30 days as aforesaid, against the conviction resulting in sentence or order until the expiry of 7 days from the date on which such appeal or petition is disposed of, or any further appeal or petition is preferred against the order or sentence within 7 days until such further appeal or petition is disposed of.
There's one question has come actually. Under the disclosure of interest, one of the director refuses to give the details of the relatives in MBP1 form. Is it correct?
He has to give, otherwise some of the provisions, because there is a relative definition under the Companies Act. So for you to ensure compliance of the provisions, you will have to take the list of relatives.
See, one more thing is there, because I also came across. Now, what happens is, in one of the directors, his own brother, let us assume, he is there, they are situated in the different places. He really does not have much of the detail about him, what he is doing, what is the thing, etc., other thing. So, genuinely, he does not have anything in his knowledge. So, if you are telling that what is the detail, etc., and all these things, since he did not have any information, he says his brother is doing what is his, I have no idea about all those things. I have no knowledge about it. Then what happens?
Probably in those kind of cases, one may have to, give some affidavit or some sort of affirmation. But still, how far that would be defendable under, with regulators is something to be tested.
Yeah. So, in continuous to that, there is somebody has put up the question: what is the remedies are available to encourage the director to approach either to ROC or NCLT? Can NCLT declare the EGM proceeding? I don't know what is this question.
No, this is in continuation of the earlier question, sir, where the private company had 3 directors.
Okay.
2 directors have pushed out 1 director. That one we'll take it up when we.
Okay, that we'll take it later. Yeah. See, one thing is there. Whenever he gives the information relative, probably to the best of knowledge, what he knows, he has to disclose. We'll have to try to get the things. If the information is not really available, I don't think anybody can do anything. But we'll have to keep asking the question. We'll have to get the answer to the extended
Correct.
cover is there. That's what I would say actually. Yeah. Yes, go ahead, Disha.
If a director is removed in pursuance of the provisions of this Companies Act, then also he has to vacate the office. Then, if there is a loss of employment in holding a subsidiary company, having been appointed a director by virtue of his holding any office or other employment in the holding subsidiary or associate, then he ceases to hold such office or other employment in that company. Section 1.
That is also one of the significant provision actually, because in bigger companies, they used to appoint either the KMPs or senior management personnel as directors in some of the group companies. Sometimes when they retire, this provision should be, noted, and it has to be, ensure that this is noted and complied. Sometimes after they retire also, they used to continue. There could be inadvertent omission there. Yeah, go ahead, please.
Yeah. Section 167(2), penalties for acting as a director after vacation. If the director knows that he has already become vacant on any of the account mentioned in disqualification specified in subsection 1, then he shall be liable with a punishable with fine which shall not be less than 1 lakh, but which may extend to 5 lakh rupees. Section 167 we specify that if a director vacate their office under any of the disqualification specified in subsection 1, then the promoter in his absence, the central government shall appoint the required number of director and who shall hold office if the directors are appointed by the company in the general meeting. So 167(4) mentioned that additional grounds for the vacation by private company. A private company may, by its article, provide any other ground for vacation of the office of director in addition to those specified in subsection 1. There's a famous case
Except for
law.
private companies, there have been some clarifications by MCA under the old act that by virtue of that provision, the private company should not try to circumvent what is given under the Companies Act. They cannot dilute the intent of the law given under the provisions. Can be over and above that.
I think long time back, I think the earlier act, there was one particular provision used to be there, what we call share qualifications. The company, once he is appointed as a director within this particular specified time, he has to actually get the necessary share in order to hold the share qualification. That used to be one of the things were there in most of the companies actually. It is more so in the private companies. In order that he has got the interest in the company. So in such a cases, if those share qualifications is not obtained in the specified time, then automatically the directorship come to an end because he has failed to obtain the share qualification. That is what I remember in earlier. Any other things in your opinion?
No, I don't think that was that qualification shares we used to call it actually. We used to put it in the articles itself that he has to hold minimum so many number of shares.
Correct. Anyway, that has been done away with that later.
Yes, but the new act is not there.
Now it is the choice of the company whether they want to have it, they don't want to have it. It is up to them. But the law does not mandate that. Yeah. Yes, Disha, go ahead.
Famous case law, Kingfisher Airlines and Vijay Mallya in 2016. So the background of the case is Mr. Vijay Mallya, the former chairman of the Kingfisher Airline, was forced to vacate his office as a director following the airline financial collapse and his inability to pay the creditors, employee, and a service provider. There was a massive debt and a financial mismanagement led to Mr. Mallya's removal from his directorial position as he was declared a willful defaulter by the Indian banks. Disqualification aspect, Mr. Mallya was disqualified from holding directorship in any companies under the Companies Act 2013, and he was also banned by the SEBI from assessing the security market and holding any managerial position in listed company due to allegation of fund misappropriation. Section 168, resignation of director. So if the director resigned, he has to give the notice, a written notice to the company. The board must take a note of the resignation, inform the registrar, and include the resignation details in the director reports immediately following the general meeting. And the director should also send a copy of the resignation, including reasons, to the registrar within 30 days of the resignation.
When you talk about the resignation of the director, it is the right of the director to continue or resign. That is number one. Whenever he gives a resignation letter, he can actually mention the resignation take effect from what date. If there is nothing is there, it is immediate date. And second thing is there is no question of, the matter is being considered, it is being approved by the board, resignation accepted, then is really no such procedure is there. The moment he delivers the letter, his resignation takes effect either with immediate effect or whatever the effective date, what he has put actually. The board has got the duty only to take note of the resignation. There is nothing beyond that. Yeah.
Right. The board is only to note, they need not approve it actually. And as per section 134, the fact of resignation to be mentioned in the board's report at the end of the financial year.
Yeah, that is right. Yeah.
So what will be the effective date of the resignation? The resignation become effective on the date the notice is received by the company, or the date, if any, specified by the director in the notice, whichever is later. So liability of the director, the post resignation. The director who was resigned shall be liable even after his resignation for the offences which occurred during his tenure.
Yeah, that means if
Vacancy.
he was a director during which time any offences has actually taken place, he is equally liable. There has been n number of cases, not only the past director, even the past company secretary, even the past chief financial officer, that means KMPs, they also been penalized by the ROC for the appropriate period where they were there actually even after their resignation that continued to hold. Yeah.
Vacancy by resignation. If director resign, the promoter or the central government have to appoint a new director, and they have to serve the office until the company appoints new director in a general meeting. So Rule 15, notice of resignation of director. The company shall within 30 days of the date of receipt of notice of resignation from director intimate the registrar in form DIR 12 and post the information on its website if any. So copy of resignation of director to be forwarded by him. Him as a director, filing the resignation with the registrar. Director within 30 days of resignation forward a copy of the resignation and the reason for it to the registrar using the form DIR 11 along with the required fees as per the company registration office and fees rule 2014. So DIR 11 form is an optional form. Every director are not for filing that form. So we can directly, company can directly file form DIR 12 and inform the registrar about the same.
Earlier, DIR 11 was actually required, it was actually mandated, but the law is modified because it has done away with that. It has given the option. That is why the language of the law, if you actually see, in the first case, it will be the company shall, and the second case, it is the director may. So that means it is the option of the director. But it is always better for the director to file the DIR 11 to safeguard his own interest. Yeah.
No point is that the reasons for resignation, which you are going to mention in the resignation letter is very important because that will be attached to the AR 12. I've seen some cases where the directors have mentioned, due to lack of non-availability of time, they are resigning, but they immediately got appointed in some other company. There have been questions raised in those regard. So one has to be careful while citing the reasons for resignations.
Yeah, you have got a very, very valid reason. This company, he does not have the time. How can he have the time in other company?
No, this was reported in the media actually in one of the listed companies actually.
Yeah. So people have to take.
If I remember correct, I think one person from the Godrej family who resigned in a listed company gave a very detailed reason which were circulating in a lot of groups actually, which appeared to be very, straightforward and genuine actually.
So there is
somebody has actually put here, even in slight mismatch in the resignation letter given by the company and the director matters.
Company does not give a resignation letter. It's a director who gives it.
No, he probably means Company disclosing the reason for resignation. I think that's what.
No, one has to go by what the director gives. There is no other choice.
Yeah, that's right. Yeah. Yes,
So,
Disha, go ahead.
special provisions for the foreign directors. If the company who has already filed DIR 12, a foreign director may authorize practicing chartered accountant, cost accountant, company secretary, or any other resident director to sign and file DIR 11 on their behalf, including the reason for the resignations. So, the case law CETC Renewable Energy Technology India Private Limited. CETC Energy Technology India Private Limited is a company involved in the renewable energy sector. The director in question submitted their resignation to the company. The company delayed the filing of the resignation with the ROC exceeding the 14 days grace period. The ROC initiated the adjudication proceeding against the company and 4 of its directors for his lapse. Legal provision involved is Section 168. Adjudication by the registrar of the company on 24 July 2023, the ROC imposed a penalty of rupees 2.85 lakhs on the company and the 4 directors for the delay in filing the resignation. The appeal on 22nd August 2023, the company and its director appealed the order to the regional director in Hyderabad. The regional director reviewed the case and reduced the penalty from 2.80 lakhs to 2 lakhs. Section 169, removal of directors. So, general removal process, a company can remove a director except those appointed by the tribunal under Section 242 through an ordinary resolution, and the director must give a reasonable opportunity to be heard before the removal. Provisions for the independent director. Independent director reappointed for the second term under Section 149(10) can only be removed by passing special resolution, and they must also get an opportunity to be heard. Exemption for proportional representation. Subsection does not apply to the companies that have opted for the proportional representation method under Section 163 for appointing at least 2/3 of their directors. So, special notice requirement for any resolution to remove a director or to appoint somebody in place of the director, so removed at the meeting at which he is removed. Director has a right to respond. On the receipt of the notice of a resolution for removal, the company must send a copy to the concerned director. Whether he is or not a member of the company shall be entitled to hear on the resolution at the meeting. Director representation. Wherever the notice has been given of a resolution to remove a director, the director concerned shall make a respect thereto representation in writing to the company and request his notification to members of the company. The company, if the time permit it to do so, in any notice of the resolution given to the member of the company, state the fact of the representation having been made, and a copy of the director representation should also be sent to every member of the company, whether the representation was received before or after the receipt of the representation by the company.
There's one question has been actually put up saying that, say resignation notice received on 1/8 and the resignation date written in the notice is 5/8. In the case of different dates for filing a DR 12 and a DR 11. No, here you are saying resignation notice is received on 1/8. Okay, no problem. But the resignation date is effective from 5/8. So that means the effective date is only 5/8. No, it is not 1/8. No. Although letter is dated 1/8, he is giving the intention saying that he would like to vacate the office of the directorship from effective from 5/8. So that is the date by which we will have to go. In both the cases, that will be the case in DR 12 also, DR 11 also. The effective date of the resignation is going to be what is mentioned there, not the date of the notice when it is written. Am I correct?
Correct, sir. Correct. Whatever is the date of effect mentioned in the letter, we need to go by that.
Yeah, one thing could be possible because the law says the letter when it is received by the company. Suppose he says the letter without mentioning the date and he sends it by post. The company gets it after 3-4 days. Then in which case the question may come, but I think Nowadays, I do not know, resignation letter has to be delivered to the letter, he has to obtain the receipt. That is what I think it is to be attached with a form, if I'm not mistaken. So in the case, the director also ensured it is actually delivered, it is not posted. Actually delivered at the company, he should know the date, that is the date in which it takes place, I think so. Yeah.
One more question was there with respect to one private company.
Yeah.
Where, there were three directors and two directors removed one director.
Yeah.
And as per the provision, that the other director has a right for a representation, which he can give it in writing, which the company is supposed to circulate it to the members or make have it read at the meeting. And the director himself can be given an opportunity to make an oral representation at the meeting. That's what is the provisions of the company law say.
Yeah, you're right. Once the notice is actually circulated, if there is a sufficient time is there, if the director gives the explanation, that also need to be circulated. If the time is actually short, then he has given the opportunity to represent himself during the meeting. That is what the law actually says. Yeah.
One pertinent thing here to notice is that if there is a special notice for removal of directors, there is no need for explanatory statement actually. In other words, probably you don't have to give the reason for removal. That's what is the position of law, though it is a bit strange, but that's what seems to be the position of the law.
So copy of the representation is not signed due to insufficient time or for the company's default. The director may, without prejudice to his right to be heard orally, require that the representation shall be read out at the meeting. And if the tribunal believes that the representation has been misused for the defamatory purpose, it can prevent the circulation and order the director to pay the company's cost. So, filling the vacancy, a new director appointed to fill the vacancy created by the removal at the same meeting, provided a special notice was given. The new director will serve the remaining term of the predecessor directors.
There is one question has been put up. If a director is actually appointed after the issue of AGM notice, whether it is required to be regularized in this AGM or in the next AGM.
Director appointed after the AGM. See, in that case, you would have been appointed as an additional director, right?
Yeah.
Obviously, you'll have to regularize the next AGM because he holds office till the AGM.
Because he says
the commencement of the AGM. In fact.
He says the current year of the AGM, the current year AGM notice has been issued. If I understand the question, what he says is the AGM notice has already been issued for the current year, and after the issue of the AGM, probably he is appointed as additional director by the board of directors. His question is whether the regularization is required to be done in the coming AGM or in the next AGM.
After the notice has been issued. Okay.
Yeah. That is what the question reads. If the director appointed after the issue of the AGM notice, whether it is required to,
yeah, because the words used in the provision is, he will hold office till the ensuing AGM actually.
Yeah.
That's what is this is a little highly technical, I feel. Maybe the option is to have an addendum to the notice and get it regularized in that AGM itself. I think if it is a private company, that is much easier. In case of a listed company, probably will have to put an addendum and then take it up in the as a business, new item in the AGM actually.
Yeah,
but again, if it's for a e-voting and all that, the timeline and all that, it becomes tricky.
Yeah. One more thing is there. As you rightly say, the addendum of the notice is actually required to be issued. If insufficient time is there or something like that, maybe the addendum can be published in a widely circulated newspaper for the information as well as it is posted to the members. I have seen such addendum in some of the companies doing it insufficient of the time because the language used in the law is till the ensuing AGM.
Correct. Yeah. Another problem will be like, whether you are giving sufficient notice for this particular agenda item.
Yeah.
Is there a shorter notice consent required? All that will come into play.
Correct. And another question has come actually. In case of the resignation, DR 12 is to be filed within 30 days from the date of the receipt of the notice. Whether DR 11 is to be filed within 30 days from the resignation. Now my question is, say director received a notice on 1/8/24, whereas the resignation date mentioned is 5/8. The 30 days time for both will be different.
I think you'll have to go by the resignation date. The 30 days time starts from there.
Yeah, 30 days time will start in both the cases effective from the effective date of the resignation, that is 5th of August.
Correct.
Not the date or something like the receipt. The effective date is the starting point for counting 30 days. Yeah. Yes, go ahead, Disha.
Casual vacancy. If the vacancy is not filled during the meeting, it may be filled as a casual vacancy under the Companies Act, and the removed director cannot be reappointed by the board. Nothing in this section shall be taken as depriving a person removed under the section of any compensation or damages payable to him in respect of termination of his appointment as a director as per the contract or the terms of his appointment as a director, or any other appointing terminating with that as a director, or as derogating from any power to remove a director under the provision of
One point which I thought I will discuss with you, Mr. Bala sir, is there a mandatory requirement to fill the casual vacancy?
It is up to the board, because you see what happens is there are many factors. Whether the quorum requirement is actually fulfilled. Because in no case the quorum requirement can fall below actually. That is number one. If it is going to affect the quorum requirement, then definitely the casual vacancy is required to be filled. But if the number of directors are more, if somebody actually, fallen the casual vacancy, the board may take a call. They decided not to fill up the vacancy. That also can be done. There is no mandatory requirement. You must fill the casual vacancy arisen unless you have an intention to bring another director in the place of the vacant policy. You want to maintain the number.
My question was from a different perspective actually. If there
Yeah.
is a casual vacancy, when you are appointing a new director,
Yeah.
whether you will appoint him in the casual vacancy or can you appoint him as an additional director? Because during my audit days, I have found many companies, which has appointed a person as a new director in a casual vacancy, miss the tenure, tracking the tenure, because the appointee director is entitled to hold office for the tenure of the original director.
Correct.
In a casual vacancy. So what we usually suggest is to not to fill the casual vacancy, but appoint him as an additional director, so that this kind of errors will not creep in. From that perspective, I asked actually.
Yeah, what you are saying is, I 100% agree. It is actually the intention. If you are saying that you want the new director to hold the office till the original director, then you have to go by the casual vacancy. If that is not the case, as you rightly said, to avoid all these complications, etc., altogether you forget about the casual vacancy, appoint a new director as additional director, and you again,
So the ensuing AGM, you get it ratified, then it
that's
gets
all.
over.
He continue to be there. This is actually a practical approach of each the company. They have to take a call.
Correct.
There is no mandatory requirement. You must fill it or you should be like that. It is not like that, according to me. Yeah.
So the famous case law is Tata Sons versus Cyrus Mistry, India in 2016. So Cyrus Mistry was appointed as the chairman of Tata Sons in 2012, succeeding Ratan Tata. However, in October 2016, he was removed from his position by the board of directors. The removal was due to the breakdown in the trust and differences of over management style and strategy. Mistry alleged that his removal was illegal and without the proper procedure.
But my one point here is that
Mr. Mistry,
when a person is being removed, when a managing director is being removed, even though there is no express provision to remove a managing director under the Act, by virtue of the powers of appointment, the board is entitled to to remove a person from the position of an MD. But still, he may continue to be a director. So to remove him from the director, you may still have to follow the removal procedure, unless and until your resolution for appointing the managing director says that on vacation of office as an MD, ipso facto he will cease to be a director. Then that's a different case, that the shareholders would have already approved. So there is a bit of nuances here, actually.
Yeah,
Any
you are
point
right.
you can tell us, we
Very
can share.
valid. You are right. The very valid point. Because directors appointed the shareholders. So when the shareholders has actually appointed the director, it governs the removal procedure. But it is actually the board of director who decide who could be the managing director. As you are rightly said it is absolutely correct. If they are removed the managing director, it is fine, but he continued to be a director.
I've seen some of the companies in their notices clearly mentioning that if he ceases to be a managing director, his office of director shall ipso facto become vacant.
Yeah.
So there is no further action required by the company.
The one question has actually come for an independent director, first term through the special resolution for a term of 5 years, second term through a special resolution for a term of for a term 1 year to 5 years. But
No, what, sir, the question is for
yeah,
first term as well as second term,
okay,
the type of resolution required is special.
yeah,
Okay. And there is a cooling off period of 3 years.
yeah.
After that, again, if he's going to appoint it, he says the law is silent as to what is the type of resolution. It is as good as a fresh appointment. You will follow the first term.
Yeah, it is actually a fresh appointment. After the
Yeah.
cooling period, when you talk about it, it is a fresh appointment. You have to follow the same thing. There is
There is no
question
baggage of history there actually after cooling off period.
You cannot say it is the third term or fourth term. It is a fresh term, starting first term, second term. Yeah. Yes, Disha, go ahead.
So Mr. Mistry challenges removal in the NCLT, claiming it was mismanaged. The NCLT ruled in favor of Tata Sons, stating that the board had a right to remove him. The case was later taken to the NCLAT, which reinstated the Mistry as a chairman. However, the Supreme Court of India eventually upheld the NCLT decision, affirming the Tata Sons' right to remove Mr. Mistry. Mr. Mistry was permanently removed as a chairman, and the case was underscored the complexity of corporate governance and the boardroom politics. ICICI Bank versus Chanda Kochar in 2018. Chanda Kochar was the CEO and the MD of ICICI Bank, one of the India's largest private sector bank. Mr. Kochar was accused of conflict of interest and unethical conduct in sanctioning the loan to the Videocon group, which had business tied to her husband. Following an internal investigation, she was asked to step down. ICICI Bank conducted an independent probe that would found her guilty of violating the bank code of conduct. As a result, Kochar was terminated with the retrospective effect, and her benefit was revoked. The case underscored the importance of transparency and integrity in leadership roles, leading to stricter scrutiny of the corporate governance practices in Indian banks. Yes Bank versus Rana Kapoor in 2019. Rana Kapoor was the co-founder and CEO of Yes Bank, one of the India's prominent private sector bank. Mr. Kapoor was forced to step down by the RBI in January 2019 due to concerns over governance issues, deteriorating the asset quality and allegations of the financial misconduct. Mr. Kapoor removal was followed by a severe financial crisis at the Yes Bank, leading to a government-led restructuring and eventual bailout. The case highlights the critical role of regulatory oversight in maintaining the health of the banking sector.
So one question has come actually. While appointing an independent director as a non-independent director, should the commission paid, which was more than 10%, be taken into account? And if so, can that person be appointed as a non-independent director?
The question is not clear actually.
While appointing an independent director as a non-independent director, should the commission paid, which is more than 10%, be taken into account? If so, can that person be appointed as a non-independent director?
Commission is ceiling is 1% actually.
Yeah, it cannot be 10%. It is actually 1% only. That is one thing. But I think probably, I do not know. We can ask him to clarify. You know, law provides actually you can pay a more commission to the independent director than the other director, but there cannot be a discrimination between the independent director.
Correct.
So probably in this case, when he is independent director, he might be getting a higher commission. When you are appointing a non-independent director, what about this aspect? That is what it appears to be, to my mind, the question. Can you clarify, Satyanarayan? What is, by understanding, correct or something else in your mind?
Rephrase the question in a little more, getting more clarity.
Satya, give us a little more information on that.
Probably we can go ahead.
Okay.
We can.
Yeah.
Section 179, Powers of Board. So the board is empowered to exercise all the power and perform all the act that the company is authorized, subject to the provision of the act and company's memorandum and article of association and the regulation made by the company in a general meeting. So there are the limitations on the power of the board. The board cannot exercise any power or do any act or thing which is direct or required, whether under this act or by the memorandum or articles of the company or otherwise exercised or done by the company in general meeting. The board of the company shall exercise the following power on behalf of the company by means of resolution passed at the meeting of the board, namely making calls on the shareholders for unpaid money, authorizing buyback of securities, issuing securities including debentures, borrowing money, investing company funds, granting loans or providing guarantees or securities for loan, approving financial statement and the board reports, diversifying the business, approving amalgamation, merger or reconstructions, acquiring control or substantial stake in any other company, and any other prescribed matters. Delegation of power. The board can delegate certain powers related to borrowing and investing and granting loans to the committee of director, managing director, manager, principal officer, or a branch office subject to specific conditions. Acceptance by a banking company in ordinary course. Deposit of money from the public prepayable on demand or otherwise, withdrawal by check, draft, order or otherwise, or placing the money on the deposit by a banking company with another banking company on such condition as the board may prescribe, shall not be deemed to be a borrowing of monies, or as the case may be, making a loan by a banking company within the meaning of these sections. Nothing in clause D, that means borrowing of money, shall apply to borrowings by a banking company from another companies or from the Reserve Bank of India, State Bank of India, or any other banks established by or under any act. Dealing between a company and its banker, the exercise by a company of the power specified in clause D, that is borrowing of money, shall mean the arrangement made by the company with its banker for the borrowing of money by way of overdraft, cash credit, or otherwise, and not the actual day-to-day operation on overdraft, cash credit, or other accounts by which the arrangement so made is actually availed of.
There is one question has actually come. As per the definition of the director, which says, director is a director appointed to the board of the company. Does this mean that only de jure director shall be considered as a director and not the de facto director, which may include person having influence over the company? I think in this particular case, I think you have to go through 1956 Act.
He's talking about shadow directors.
So to remove the doubt which was there in the 1956 Act, the 2013 Act very clearly brought in a director is a person who is appointed by the board of directors. The consent of the shadow director, the person who is having a control, who is influencing and all the things, those concepts are actually gone. Now the director means it is duly appointed by the director. That means in those cases, if the person really exercises the control, he need to be appointed by the director, by the board only. Then only he is the director, otherwise he is not. Is my understanding correct, Shanmugam?
Yeah, correct, sir.
So the question what is rising is relevant, which was there in 1956 Act and not relevant in 2013 Act. If he is not appointed as a director by the board, that's all, he is nobody. And again, the officers default also very categorically spelled out in definition section. Yeah.
Correct.
Yes, Disha, go ahead.
Restrictions on the powers of board. The board of director of a company shall exercise the following
There
power.
are two more questions. Can we deal with that? One is before this 180, there was another question. Do we need to file Form MGT 14 when a committee exercises the borrowing powers delegated to it? So, in my view, it depends upon the nature of delegation. If they are given certain ceiling limits to the committee within which they can consider and approve the proposal of borrowings, then you may have to file the MGT 14 when the committee exercises powers and probably enclose the delegation resolution also. Otherwise, the MCA may not understand why the committee resolution is being filed. Over to you, Pala sir.
Yeah, you're absolutely right. Any borrowing power is exercised, MGT 14 is to be done. But if the resolution passed by the committee, you have to enclose both the documents, you have to file it. That is very clearly. I agree with you 100% what you're saying.
Yeah, go ahead, Disha.
So restrictions on the power of board that they have to exercise the following powers only with the consent of the company by special resolution. If you want to sell, lease, or otherwise dispose of the whole or undertaking or substantial the whole of the company, or where the company owes more than one undertaking of the whole or substantially the whole of any such of undertakings. Undertaking shall mean an undertaking in which the investment of the company exceeds 20% of its net worth as per the audited balance sheet of the preceding financial year, or an undertaking which generates 20% of the total income of the company during the previous financial year. Substantially, the whole of the undertaking in any financial year shall mean 20% or more of the value of the undertaking as per the audited balance sheet of the preceding financial year. To invest in the trust securities, the amount of compensation received by it as a result of any merger or amalgamation. Borrow money where the money to be borrowed together with the money already borrowed by the company will exceed the aggregate of its paid up share capital, free reserve, and security premium, apart from the temporary loans obtained from the company bankers in the ordinary course of business. Temporary loans means loans repayable on demand or within 6 months from the date of the loan, such as the short term cash credit arrangements, the discounting of bill, and the issue of other short term loan of a seasonal character, but does not include loan raised for the purpose of the financial expenditure of a capital nature. To remit or give time for the repayment of any debt due from a directors.
I think the Satyanarayana has come back on this question, independent director versus non-independent director. He says, I will rephrase the question. While appointing the non-executive, non-independent director as an independent director, if they must fulfill the independence criteria, will the payment of the commission to the director be considered while calculating the 10% limit of the total amount, or will the exemption as remuneration? I think commission will not be considered as a pecuniary interest at all. That is what the MCA notification says. Correct, no?
Correct.
Because commission is not considered as a pecuniary interest at all. The commission payment is subject to whatever the limit is prescribed, that within that 1% commission, whatever is payable, that is so long as you are sticking in, the distribution of the commission between the non-independent director, independent director is up to the company. Of course, the independent director can be paid more commission than the non-executive director, but only thing is among the independent director, there should not be a discrimination. That's what I understand. That is what it is referred here. Yeah.
But any commission payment is a payment which is allowed expressly under the provisions for any director, actually, including independent directors. If at all he gets anything, makes anything over and above the commission in terms of any specific contracts, any services he renders, then that may attract that, the threshold limits of these, this pecuniary and all that. So only we have to be mindful of those kind of incomes rather than the commission.
For incorporating a wholly owned subsidiary company, is the board empowered to take a decision?
Yeah, it will be investments, 186, right?
Yeah.
So it will have to, one has to take the approval of the board.
Sir, my question
And
is
you will have to be mindful of the layer also there. So you will have to take a board approval.
okay. And one more thing is there. My question is, in the private committee having 3 directors and the remedies available to the expelled director. That means he is coming back to that original question. That means, three directors. One is holding a majority, other is the wife, the third is actually the brother, and who is actually removed. He says, what is the remedies are available for that?
Yeah. Remedy could be, you could probably go to the NCLT, depending upon the nature of events, whether he can resort to oppression and mismanagement is something to be examined. Or if his right as a director under the during the course of removal is not given to him, then probably they may have to aver in his petition accordingly.
Okay, another thing is there, one more question is there. Company passed the special resolution to borrow the money as per the section 181 and authorize the board. This resolution passed in the year 23 March. Can the same resolution is valid 2024? I think once you actually pass the resolution, what is the power of the borrowing? So long as you remain within the power of the borrowing throughout the period, there is no need to take the resolution every year. Because once you are exceeding, then that particular year, when you are going to exceed, then fixing the re-limit, etc. and all the things, you will call for the resolution. Because I have seen many companies, what they do is they actually take a resolution in such a way that so much amount and again so much percent of the increase of the paid up capital. That is what they take it actually. So whenever the capital goes up, automatically the limits also go up. So the percentage is actually indicated. Say 30% of the capital or 40% of the capital, like that they take it actually. So whenever the capital increases, proportionately that also increases. That is one thing. Wherever the company has taken the particular limit put in, then you will have a problem. The moment you exceed the limit, then you have to get the approval again. So long as you remain within the limit, it is all right. There is no problem. The same resolution will hold good. Correct, no?
Couple of points I would like to highlight here.
Yeah.
See, generally, when the resolution does not specify any time limit, the resolution is valid until any threshold limits or any other conditions given in the resolution is breached. Point number 1. Point number 2, there are certain provisions which gives specific time period for the resolution. So in that case, you will follow that time period. As and when the time period is over, you will have to go for a fresh resolution. In terms of this specific question, probably I think whether this question is with reference to the private placement, because under the prospectus and allotment rules, there was a 1-year validity period for the resolution actually for the private placement. So if it is with reference to that, one has to go by the timeline given in the provision, and you have to keep renewing the resolution as and when it is required.
In a private company, which is a subsidiary of the public company, required to file the resolution under section 179 as applicable to a public company.
Sorry, sir, I lost the question. What is the question?
In a private company, which is a subsidiary of a public company, required to file the resolution under section 179 as applicable to a public company.
Yeah, in my view, it is yes.
Because the subsidiary company, which is a subsidiary company as a public company, is also has to follow the procedure of the public company as well. So that is what the law says. In which case, yes, you have to file. If the associated email ID is wrong while applying the DIN, and for that reason the DIN cannot be registered under the V3 portal, can it be rectified through the filing DR3 KYC web form, even if the KYC is not applicable for this year?
No, DR3 KYC web form, in my understanding, is only when there is no change in particulars.
Yeah. But I think
if there is particulars, you'll have to update the KYC actually.
Yeah. Because there is something, there is a procedure is there, filing a form and actually what do you call, changing the detail which is already provided. I think he has to go by that, I think so.
Correct, correct.
Yeah. Yes, Disha, go ahead.
Lifeguard Financial Leader Limited is a financial service sector company, was found to have exceeded its borrowing limits without obtaining the necessary approval from its member as required by Companies Act 2013. The provision which was involved is 180 1C of the Companies Act 2013. On 24th June 2024, the company and its three of its directors were collectively fined of rupees 31.50 lakh for the breach of the borrowing limit. Section 184, disclosure of interest by the directors. So every director shall in the first meeting of the board in which he participates as a director and thereafter at the first meeting of the board in every financial year or wherever there is any change in the disclosure already made, then at the first board meeting held after the change disclose his concern or interest in any company or companies or body corporate firms or other association of individual which shall include the shareholding. Disclosure in contracts or arrangement. The director shall disclose their interest or concern in any contract or arrangement with a body corporate in which such directors or such director in association with any other director hold more than 2% shareholding of the that body corporate or is a promoter, manager, CEO of that body corporate, or a firm or an entity in which they are a partner, owner, or a member, shall disclose the nature of his concern or interest at the meeting of the board in which that contract or arrangement is discussed and shall not participate in such meeting. Voidable contract, a contract or an arrangement entered into by company without disclosure under subsection 2 or with participation by a director who is concerned or interest in any way directly or indirectly in the contract or arrangement shall be voidable at the options of the company. Penalties. If the director contravenes any of the provision, then such director are liable to a penalty of rupees 1 lakh. Disclosures by a director of his interest. Director shall disclose his concern or interest in any company or companies or body corporate, firms or other associations of individual by giving a notice in writing in form MBP1. It shall be duty of director giving notice of interest to cause it to be disclosed at the meeting immediately after the date of the notice. All the notice shall be kept in the registered office, which shall be preserved for the period of 8 years from the end of the financial year to which it relates, and shall be kept in the custody of company secretary of the company or any other person authorized by the board for the purpose. So the case law is India Bulls Housing Finance Limited, a prominent financial service company. Director of India Bull Finance Limited made a necessary disclosure of their interest in firm MBP1. However, the company failed to take this disclosure on record as required by law, leading to a violation of Section 118. This oversight triggered an adjudication process by the ROC for non-compliance. This sections deal with the minutes, Section 118 of the Companies Act deal with the minutes of the meeting of the board of director, committees and general meeting. It mandates that the company must keep accurate meetings of every meeting, including any disclosure of interest made by the director under Section 184 of the Act. Form MBP1 is the prescribed form for every director to disclose this interest in any company, body corporate firm or other association of individual. The order was passed on 21st February 2023. The penalties was imposed not only on the company but also on an individual officer, reflecting the personal liability of director and the key management personnel for the corporate governance failure. This case serves as a warning to other companies about the importance of adhering to the statutory requirements for the recording disclosures. Penalty was imposed on the company rupees 50,000, managing director 10,000, 3 director collectively 30,000, 1 director 5,000, CFO of the company 10,000, company secretary 10,000. Total penalty was rupees 1,15,000.
As Disha puts it here, all these penalties which are levied on the individuals, they are going to pay from their own pocket, from own source of income. There is no question of any reimbursement from the company or company bearing the things, etc. That does not happen because many times adjudication officer is verifying this information from his source, asking for the bank details, source of the income, etc. and other thing and that. So it shows very clearly how diligently the company secretary need to perform their duties. Yeah.
184, another important is that the duty of the director to make a disclosure. Non-compliance of 184 leads to penal consequences for the director per se, not on the company, unless when the company does not take note of the disclosure in the board meeting, as informed by Bala sir during the initial stages of this discussion. And one more point one has to remember is that whatever disclosure we receive under 184, that has to be entered in Part B of the MVP4 register. That's a record of the disclosures made by the directors. So in case if you are not maintaining the 184 disclosures properly, it will be difficult for any regulator to validate the entries in MVP4. That would be twin liabilities which could arise actually.
Yeah, you are absolutely correct actually, because you know what happens is the disclosure is prima facie the duty of the director to inform the disclosure. That is number one. He does not inform, then the consequences will be that the concerned director will be actually fined, penalized, etc. and other thing and all. That is one issue. Second issue is that he actually informs and the company does not take into account. Company is not taking note of it, as we see in this particular case. That is another thing. And not only that, even after company taking it, as you rightly say, Shanmugam, the statutory register is not updated. Then again, that attracts a fine. So one has to be very, very careful, not only getting recorded and again the action arising out of it, entering it in the recorded register, etc., maintaining the register at all time, updated. That is also a must. Yeah.
So NSGL Nidhi Limited is a financial institution operating under Nidhi Companies Framework, was found in violation of the Companies Act 2013. Three director of NSGL Nidhi Limited failed to disclose their interest in other entities as required under Section 184 2B. This omission was detected during a compliance review by the ROC. The failure to disclose this interest posed potential conflict of interest, the transparency and the integrity of the company legal governance. Legal provision involved is Section 184 2B of the Companies Act. The order was passed on 11 October 2023. The ROC imposed a fine of rupees 3 lakh on the three directors responsible for the non-disclosure.
Excellent, Disha. Nicely you brought out all the relevant sections and.
I think there are a few queries.
Yeah, I'll take that. I'll take that. So let me appreciate Disha for her excellent presentation and putting the things together with the relevant case law, which was really, nice to see all these case laws. Also, many case laws have come, but it is refreshing to know what is the relevance, what is the thing it is actually got. Nice. My sincere appreciation to Disha. And one more thing I also want to tell the audience at this point of time. You might have heard the name Disha. She is also there always. And in the past also we spoke. All along, Disha has been actually in the behind the show. She was actually managing, ensuring, making the people to do the things. And she was excellently supporting the people for all these matters, even including assisting them in making the presentation, etc. Today is the day where she has actually come in the forefront. She herself is actually made a presentation. Excellent, Disha. Congratulations.
Thank you, sir.
Let us go
Excellent presentation, Disha. Your presentation is very specific, focused, and very relevant case laws. You picked it up and put it. I am sure the people who have attended, all the professionals who have attended this program would have definitely benefited in these 2 hours immensely. They will have good takeaways actually.
Disha, you will be very pleased to note more than 250 was the case. Now
Yeah.
about 217 people are all there
No,
listening
it went
to
up
you.
to 234. I noted it actually.
Yeah.
234 went up.
Yeah.
Thank you, sir. Thank you.
No, that shows, not only the importance of the topic, the relevance of the discussion, what you actually brought in. That is what I would like to say. When we say knowledge sharing, it is really a knowledge sharing. That's okay. Let us look into the questions. Whether the NCLT has the power to appoint the director when the company is insolvency and the powers of the directors are suspended. Additionally, the insolvency is on only one project. Can suspend the director, make an application to the NCLT for the appointment of the directors.
Once this company goes for insolvency, as per the IBC code, the existing directors' powers are suspended. The entire power goes to either the liquidator or the IRP actually. So it depends upon how the insolvency process evolves, what prayers the liquidator or the IRP makes. So it will be left to the course of the insolvency per se. That is what is my view.
Absolutely, you are
And
right.
as per the provisions of IBC, the powers of existing directors get suspended. They cannot do anything.
Yeah, that is right. They don't have any remedy. It comes to an end and it travels down to either the official liquidator or insolvency professional, whatever it is. If the rotation of the director is applicable to the private company, which is the subsidiary of a public company.
Public company is deemed to be a public company, so that will have to be complied.
Yeah, because once again, the same question which actually comes, because law is very clear. If you are a subsidiary of a public company, then you are as good as a public company only. So all the laws which are applicable to the public company will automatically apply. What can be the reason independent director not entitled to the stock option? This is one prominent question which every seminar, most of the people have been asking.
The independent directors are expected to drive governance, not profits. The primary point is that they will act as a guiding force to the company to ensure the company follows the good governance and it complies with all the applicable regulatory requirements. It takes care of all the stakeholders, not just the promoters. So the law has consciously made it to ensure they are not profit driven. So because if they are, if they are given stock options, then the more the profit, the better the stock price will be. So they wanted to delineate the independent directors. The regulator wanted to delineate the independent directors so that their focus is not on the performance is important, not on the performance per se, but a lot of other aspects as well. That is what is my understanding. Over to you, Bala sir.
I also agree with you because the whole purpose is when you talk about the independent director, they want to be unbiased or they are not attached to anything. They are actually not given any particular interest, etc. That seems to be the mind of the regulator. That is why it is not there. As per the section 164(2), a person who has been director of a company which has not filed financial statement for continuous period of 3 financial years shall be eligible to be reappointed or appointed in other company for a period of 5 years from the date on which the said company fails to do so. How the question is, if the company fails to file the return the financial year 2009 and the default continues till date, whether any director of that defaulting company can be appointed as a director of any other company as 5 years from the date of failure are completed, specifically on the background of the non-compliance continues till date. So he says default is actually 2009 and he is talking 2024 today. That means he's talking a period of
5 years.
Yeah. So he is bringing that 5 years concept since the 5 years period is already over. Whether he can be appointed, that's what the question is asking. Yeah.
I think this will require some factual examination.
Yeah, it appears to be something, a different aspect what he has actually brought in, highly technical. I think probably I also, frankly speaking, do not have an answer immediately for this actually, unless we get into the details. If there are no changes in the contracts under the section 184(2), Is it mandatory to obtain signature of all the directors at every meeting with the nil details?
No, I would like to probably deal with, elucidate on 189 a little bit. See, when you make an entry of the contracts in 189 registers, it is not the contracts which gets approved which will make an entry. It is the actual transactions which will record it in the 189 register. That is clear. This question I don't think will arise. As and when a transaction is entered, only that you will make an entry in the register of contracts under section 189. For example, if there is an in-principle approval for a contract, okay, that per se will not get written over in 189 because in principle, though approval though might have been given, it is quite possible that you may not proceed with the contract itself. So the actual transaction when it happens only will get entered in the 189 register. So as and when the transaction happens, you will have to make an entry.
Yeah,
Sir,
absolutely.
over to Mr.
Oh,
Palas.
absolutely, you are right. Actually, if you actually see the register, it is in a contract arrangement in which the directors are interested. It is as and when it occurs, you enter. If you do not have any detail, if there is no transaction there, question does not arise at all, as you rightly say. Family or closely owned companies, now relevance is maintained. How relevance is maintaining of the territory reserve when and who inspect these registers, please? There is no question
Family
of
are
whether
closely.
there is no question
Okay,
of
please.
family owned otherwise. This is a company. Company is ultimately a artificial third individual personality that it has to comply with it. There is no question of family or not family, whether private company, public company. When you say companies are incorporated in the particular company under the same framework of the Companies Act, all the applicable laws, compliances are actually applied. That is very clear on this. Who inspect the register? Maybe public is not interested, that is okay, but regulator is interested. People who are auditing is going to be interested. Any issue comes out, people will come, they are interested, regulatory bodies. All those questions will arise, I think. Yes, CFO is required to appoint a KMP in case of the private company.
See, 203 talks about the requirement of appointment of KNPs, which includes MD, WTD, or manager or CEO, and CS and CFO. So, if you are appointing somebody as a CFO without the need under 203, there are two views. As long as you appoint the person as CFO, he is deemed to be a KMP is one view. The other view is that in such cases, you can still state that he is not to be considered as a KMP. This is to be tested from the regulator's viewpoint. As otherwise, if you are appointing under 203, it is a KMP position. Over to you, Bala sir. Sir, I was telling on that KMP thing, CFO thing.
Yeah, 1 minute. Let me get into the chat. Yeah. Here he
What I
says,
was saying, I hope you heard me, what I said.
what is this here? He says
They are
here,
asking, is
yeah.
CFO required to appoint as a KMP in case of a private company? What I said was, as long as you appoint somebody under 203, he is automatically a KMP.
Yeah.
There are companies which, though they may not require, though 203 may not be applicable, that is, they may not need a mandatory CFO. In such cases, there are two views. Despite no mandatory requirement, if you appoint, he can either be deemed as a KMP or you have an option in while resolving that he should not be deemed as a KMP. That is something to be tested for the regulators' views, how they will take it. Otherwise, as long as you appoint under 203, he will be a KMP.
Yeah, that is right. That is automatic. We are reading this question. I have a question regarding the disqualification and the deactivation of the DIN of a director. There was a OPC he incorporated, which later on got stuck up. I don't follow what is really the question is here.
Question seems to be incomplete actually.
Yeah. Okay. In some cases, it happens that though the company secretary tries to adhere the compliances, but the management has their own way of doing.
I think its connectivity is little erratic. For this question, probably I would answer in one of the recent adjudication orders, even for a preferential allotment where there was no separate bank account open, ROC has levied penalty. So it is for the CS to ensure whether he gets the support of the management, he has to ensure compliance of the law. That is why it is a statutory position. So one has to be mindful of that. We cannot take shelter that the management is not cooperative, or we cannot say that because of paucity of time we have not complied with the law. One has to comply with whatever is mandated under the law. So
Yeah,
I was answering to this question.
Yeah, you are absolutely correct, because the question is, there is a thorough, planning is required to do everything in terms of the compliances. There is no excuses saying that, paucity of time and other thing, all these aspects you have to take into consideration before only proceeding on that particular matter. Otherwise, if the non-compliance anyway is the non-compliance. You may have a number of reasons, but under the Companies Act is very clear. Compliance is the compliance for all the type of the company that is required to be actually done. Okay. One thing is there, see, I also seen. Now people say it is the management who's appointing a director, a independent director or a women director and other director and other thing. The non-appointment of the directors, even the company secretary has been actually penalized in cases. There are a number of cases there. The whole question is, the company secretary has been given the responsibility to ensure the compliances under the Companies Act. Okay.
And it is specifically mentioned under the duties of the company secretary under the rules also.
Yeah,
appointment and remuneration.
Yes. So in which case, he has to tell the management, he has to tell the board of directors, look here, this is what it is required to be done. There is no question. Because he has to convince, he has to get the compliance done. If he doesn't compliance done, and management is acting, they are not listening, that is very bad. Because that is why Sudhakar also used to say many times, yes, your voice is heard by the board. He used to ask very prominently. So that is the question you have to ask. You have to work towards that, because it has become a compliance regime, actually speaking. Okay. Whether the director disqualifies the appointment of the managing director or the whole-time director of the company, if the director receives summons from the court or goes for compounding. See,
Here summons does not disqualify.
Yeah.
Compounding is not a conviction, actually.
Correct. Compounding is actually compensating in terms of the imprisonment to the fine, so it is not actually a conviction. Okay.
Right.
Can we have the webinar internal audit or HEBCFC, IFFC as well as regulatory? Yes, we have taken note of it. We will definitely look into. We will conduct. There is no issue at all.
I think that can be the scale-based regulatory framework, that entire master directions of RBI.
Yeah,
we can have one session.
Is CFO required to appoint the KMP in state government companies PSU?
I don't think 203 gives any exemption. Whatever is applicable under 203, one has to comply as long as the company is entity under the company law.
Yeah, you're right. Absolutely right. There is no exemption is available because of the government company. That is right. During the grip of under the IPC, will the director sign the financial statement of the company under section 134 of the Act?
I don't think so, because the director's powers get suspended. So in between, in the process, if there is a financial statements to be drawn up, actually all the responsibilities lies with the liquidator or the IRP.
Yeah. Categorically, it is only the liquidator, the IPC professional, it is there actually, because board doesn't have any power at all. But the private company is required to have only 2 directors. Is it required to increase the number to 3? It is your choice, because it talks only
Not
the minimum.
Necessary.
It is only a minimum. Here it is your choice. You can have 3 directors, you can have 4 directors, even you can have 7 directors. There is no problem. Because minimum is required so much.
Yeah, ideally it is better to have 3, because if one director resigns or something untoward happens, the company will have only 1 director then there'll be, board composition will not be in line with the act. So
Yeah,
it's better to have
absurd,
three, but
absurd,
statutorily two is sufficient.
absolutely, you're right. Actually, in fact, what is the quorum requirement? Beyond that, you should have something in a buffer so
One,
that
correct,
the
correct.
quorum requirement is always met, even if somebody is
Meeting,
not
somebody
available.
may not attend, all
Yeah,
that is there.
correct. If the condonation of the delay has been done by the company, failed to file the financial statement, then the director can be appointed for 5 years in compliance with the section 164(2). Yeah, condonation is done and the statements are filed in this, not the conviction, because this is actually set right. It can be done according to me.
Then the default has been rectified.
Yeah, because that is what she also said in the presentation. So long as the default is actually rectified, then question does not arise. If the default is not rectified, then the question arises. In this particular case, the default is rectified.
Correct.
A CFO required to appoint a KMP in a state government PSU. The board decided general manager of the company to act as a CFO till joining the director of finance, and after joining the director of finance can be seated as the CFO be filled with the ROC.
You'll have to follow the process of 203, whatever is the interim arrangement.
Interim arrangement you can have, but the thing is that period of time in which you know to fill up the vacancy, you know to fill up the vacancy. That
Correct,
applies for
correct.
all the people. That is the case.
Yes.
So the OPC got stuck off. I think this is the continuation of the OPC question. So the OPC got stuck up through the strike-off process dated 31/3/23 for non-filing the financial and not doing the business for the 2 years. So the first question is whether his disqualification will be counted from 31/3/23 or from when. In the second question, is there any way out of the reactivate the DIN like through the revival of the stuck-off company, or we have to wait for the 5 years compulsorily?
Timeline is not from 31/3. It is with reference to the previous financial years only. So there is no relevant date. It is relevant to the financial year actually.
Yeah, that is right. I think once the DIN is deactivated, I think that will remain valid for 5 years, I believe. Correct me if I'm wrong.
I'm not sure. I'm not sure on that actually.
Can a whole-time director take charge more than one company? Yes. What complaints have to be made?
A whole-time director cannot be a director in more than one company. No, MD can be MD in more
Yeah,
than
there
one
is only
company.
a provision for MD, not for the whole-time director. Whole-time director is only for one company. It is not for the other company. Can the board take a decision for incorporating a wholly owned subsidiary company? I think this question we discussed.
This came already actually 186.
Yeah. I think that is all the questions so far in the chat box.
Yeah.
I don't think there's anything is left out. Now maybe we can see if anybody has got the question, they can raise their hands. So that is so we can, yeah, one more question has come, I think so. Can a director or WTD become a chief compliance officer of the company? Now, if you are talking the chief compliance
Compliance
officer,
office.
see,
Yeah,
if
chief
you are
compliance
talking,
officer. There is. Yeah, please go ahead.
if you are talking about the listed company, compliance officer can only be a qualified company secretary. That is very clear. If you are talking about the other company, if you are designating, it's okay, but the company secretary requirement is that company secretary has to be appointed. Yeah, you can have somebody responsible for the compliance. That is something different. But the thing is, ultimately, it's a company secretary who will hold the responsibility for the compliances. Yeah, yes, Shanmugha.
Yeah, correct, sir. You're right.
Non-listed. Okay, non-listed, then you'll have to see whether the company secretary is required, not required. If the company secretary is required, you'll have to appoint, he will be a compliance officer. If the company secretary is not required, doesn't matter, you can have somebody to ensure the compliances, but he is not a company secretary. You cannot file any DR12 form, etc., and other thing and all for him. So that is the thing. I think that's all. I think so here. Then let me see.
Last question is independent director entitled sitting fee for attending separate meeting of independent directors. There are varied practices here. Some companies do pay for the separate meeting of independent directors. Some companies do not pay sitting fee for the separate meeting of independent directors. So, in my view, they are entitled, I would say.
Yeah, so long as it is a meeting, either board or committee meeting, it is as good as the committee meeting only. So they are entitled, law does not prohibit, etc. But as you rightly say, it is a varying practices by the company, but they are entitled as per the company law. Company law does not prohibit this. Yeah.
When an individual is acting as a director with two or more companies and A limited as default in annual filing, then disqualified in other companies and remains active in director. What if the default is active in A till limited? Still says disqualification continues in other companies. This will again require some factual details. It's little technical.
Yeah, I don't think there's any hand has been risen. I think probably we can close the session. I would like to take the opportunity in expressing my sincere thanks to Mr. Shanmugha Sundaram. As usual, very vibrantly, he has given a lot of insight. He has actually given us. I personally gained a lot of things today. Of course, there are 2, 3 technical questions which has actually come given food to thought. So we'll have to think over all those things. And the suggestions has been taken. Whatever is given for the future webinar, we will do it. One more announcement I have. Next week being the 7th, which is actually the Ganesh Chaturthi festival is actually there. We will not be having the webinar for the next Saturday because of the Ganesh Chaturthi. We'll meet only thereafter, that is on 14th, we'll have the session. So excuses, 7th we will not have, but I request that all celebrate Ganesh Chaturthi and have the blessings of the Lord Ganesha. I think with this, we close the session. Yeah.
Yeah, one moment, sir. Thank you, Bala sir, for your kind words. I would like to tell the audience is Bala sir is much senior to me. I've been reading a lot of his articles actually, which is very, very enriching and to enhance my knowledge actually. Thank you for your kind words once again, Bala sir. Thank you, Disha, for the nice presentation, which was very specific, very focused. Case laws are all very well picked and it was very useful. And thank you, Mehta and Mehta, for the opportunity. It helps me also to keep learning and also keep sharing what I have learned. Thank you so much.
Thank you, Bala sir. Thank you, Nishant sir, for helping me out to carry out such a nice presentation, taking the questions of the participant and answering all.
Yeah,
I
thank
think
you.
one last question has actually come. Can Section 8 company limited by the share be converted into the limited by guarantee? Grateful if you could answer this question.
That needs a bit of examination.
Okay. Okay, I think with this we'll close the session.
Yeah.
Thanks a lot once again to everybody, to all the participants.
Thank you.
Disha, almost 146 people are there at this particular time, which actually shows your excellent presentation. Once again, thanks. You've done a very good job.
Thank you, sir. Thank you.
Thank you, Shanmugam. Thanks a lot.
Thank you,
much.
Sir. Bye-bye.
We are privileged to have you. Yeah.
Thank you so much, sir. Bye.
Thank you, sir.